Thank you. Please be seated. Okay, good afternoon, everyone. We're here on the matter of the the matter of recall charges against the City of Seattle Mayor Katie Wilson. Cause number is 26-2-26954-8 Seattle. Just for the record, I'm Judge Oishi, and we're here in King County Superior Court. We're in the King County Courthouse in my courtroom. The courtroom is open, and we're audio recording via the FTR recording system. So we have petitioners to the recall who are here in person. We also have a number of counsel appearing via the Zoom platform. I also would acknowledge that we have multiple members of the media who are here in court. I had the court's bailiff as well as the court's public information officer do outreach with the media, just as far as what the kind of media order is going to be that applies to this hearing. So let's first make introductions. So as far as the petitioners who are here physically in court, can you please introduce yourselves?
I'm Melinda Jacobson.
Okay, good afternoon, Ms. Jacobson.
And I'm Dale Osterud.
Okay, good afternoon, Mr. Osterud. Let's have counsel who are appearing via Zoom introduce themselves. So first for the King County Prosecutor's Office.
Good afternoon, Your Honor. I'm Julie Cook, and I'm appearing on behalf of the King County Prosecutor's Office as a neutral party.
Okay, thank you, Ms. Cook. And counsel for Mayor Wilson, please.
Thank you, Judge Oishi. Good to see you again. Dimitri Glitzen and Abby Lawler for Mayor Wilson. Your Honor, I do want to note, I believe there may be members of the media or the public also seeking to observe via Zoom.
Matt, how many people are via Zoom? Go ahead and let those people in.
Thank you, Your Honor.
Just for the record, as far as people who may be on Zoom, this is Judge Oishi. Anyone who's on Zoom and just observing, not an active participant, you need to make sure you keep your camera off, you stay muted, and there's going to be no interruptions, no comments being made from people on Zoom except for counsel. Okay, so with that said, let's go ahead and get started. So I want to first take a couple of steps back. So recall petitions are somewhat unusual. They're not super common, but they happen. So they've happened in the city of Seattle and King County, in different parts of the state. And recall petitions are based on specific statutory authority. So in this case, what happened is Ms. Jacobson and Mr. Osterud filed what I'm going to describe as recall charges. Those got submitted to the King County Elections Office, and then pursuant to statute, the King County Elections Office then submitted the charges to the King County Prosecuting Attorney's Office, the prosecutor's office then submitted the petition for recall that included at, I think it's Exhibit A, the actual recall charges. And so once the petition got filed into the court file, that started the clock, the 15-day clock pursuant to statute for the court to actually conduct a sufficiency hearing. So that hearing was scheduled for next Monday. I'm the assigned judge, so that's scheduled for next Monday. In the meantime, no counsel appeared for Ms. Jacobson or Mr. Osterud. Mr. Eglitzen and Ms. Lawler, who are here on Zoom, they filed a notice of appearance on behalf of Mayor Wilson. I also had issued an order, hang on just one second. I also had issued an order setting briefing schedule and setting the hearing date. That's in the court file in sub 5. And pursuant to that order, legal briefing and proposed orders, findings of fact, and conclusions of law needed to be filed by August 26, yesterday at 12 noon. So Mr. Eglitzen and Ms. Lawler, they complied with that order. They filed their briefing timely. There was absolutely no response that was submitted by Ms. Jacobson or Mr. Osterud. So fast forward from yesterday to today. Well, let me just stick to yesterday. Apparently, and really, the court was getting this information third hand, but apparently Ms. Jacobson and Mr. Osterud yesterday were having contact with the King County Prosecutor's Office, wanting to essentially get the recall petition dismissed. And so the court got forwarded some emails that we weren't a party to. Fast forward to today, Ms. Jacobson and Mr. Osterud actually showed up here at my courtroom and wanted to present the court in order dismissing the recall petition. It's absolutely inappropriate for the court to have ex parte contact with just one party. So at that point, in the abundance of caution, what I did is I submitted or emailed a copy of the proposed order that the petitioners had provided to my bailiff, forwarded that to all counsel, and then I set today's status conference just to frankly figure out what the heck's going on in this case. And I'll be frank with everyone, this is highly irregular. It's highly irregular, for example, that the petitioners would not have complied with the court's order, would not have submitted legal briefing. So in large part, except for the briefing submitted by the Mayor's Council, the court, I've kind of been in the dark as far as what's happening. So I set this status hearing for this afternoon just to kind of get to the bottom of where things stand. And that's also getting to the bottom of where we stand today vis-a-vis next Monday's hearing. Because next Monday's hearing was for the purpose of actually addressing both the factual and legal sufficiency of the recall charges. So I just wanted to kind of set forth that history as far as how we got to this hearing, especially because we have lots of media here. I want you all to be privy to the same information I was privy to and why we got to this point. So here's what we're going to do. I'm first going to hear from Ms. Jacobson and Mr. Osterud as far as finding out from them firsthand on the record here in court what it is they're asking me to do. And then once I hear from them, I'm going to turn to counsel to hear from them to see if counsel want to state their positions as well. Okay, so Ms. Jacobson, Mr. Osterud, again, good afternoon.
Good afternoon.
Okay, so who's going to be speaking?
I am.
Ms. Jacobson, you're going to speak. Okay, so Ms. Jacobson, let me kind of start with kind of a simple question. Can you tell me why it is you showed up at my courtroom today and kind of what you were trying to accomplish?
Your Honor, it's complicated. We received information that was incorrect through various legal circles.
So Ms. Osterud, I need you to actually listen to my question. What I need to know is, why did you show up in my courtroom today? For what purpose? What were you trying to accomplish? That part is not complicated.
No, I agree.
Right, so can you just tell me, why did you show up today in court? For what purpose? What were you trying to accomplish?
Okay, I'll make it as clear as possible. We received some new information that needs to be addressed.
Ms. Jacobson.
And because of that,
Ms. Jacobson, you're not answering my question.
we showed up today with this paperwork that we were instructed to go to the clerk in Superior Court this morning. And
Ms. Jacobson, let me just stop you so we can cut to the chase. You're making this way too complicated. It's my understanding, and it almost is kind of taking me, it's forcing me to read your mind, but I'm going to try to do that, and you just confirm if I'm correct. Did you show up today at my courtroom wanting me to dismiss the recall petition? Yes or no?
yes, but there's more to it.
Ms. Jacobson, have you ever been to court before?
More times than I care to
So.
but not for something like this.
Okay, so Ms. Jacobson, when you appear in King County Superior Court, there's certain decorum that needs to be followed, and frankly, if I ask a simple question, just please give a simple answer. So you showed up today wanting me to sign an order dismissing the recall petition, correct?
Correct.
Okay, now, can you briefly tell me, frankly, less than 2 minutes, can you briefly tell me why it is you want this recall petition dismissed?
There's several reasons, Your Honor. First of all, as I tried to say earlier, we found some additional information that needs to be investigated as per the charges. That's number one. Number two, we have, ever since we heard from the court, the prosecuting attorney's office, we have tried to find an attorney. I cannot begin to tell you how many attorneys I've talked to here in Seattle. Finally, as of last night, we found somebody that wants to represent us, and he instructed us that we should file a civil 41A1A, which I understand is filing a petition or whatever you want to call this paperwork without prejudice.
So we probably will get to CR 41A1A in a minute. CR 41A1A actually probably doesn't apply in this case, just because recall petitions are just kind of unusual. They're not like typical lawsuits, but we'll probably get to that later. But I just want to summarize what you said. So one, you feel like there's some additional investigation that needs to be done, and two, you want to have some additional time to retain counsel, correct?
Yes.
Got it. Okay, thank you. So with that said, Ms. Cook, I want to hear from you. And, you know, I think the starting point, Ms. Cook, if you could start with this, just to make the record clear, can you just kind of explain what the role of the prosecutor's office is and is not in this proceeding?
Certainly, Your Honor, and I think you explained it very well in your introductory statements. The prosecutor's office receives the charges from King County Elections, and to review that and prepare a synopsis and a petition for the court to review as the decision maker in whether or not there is a sufficient basis to move forward with the recall process. That's what the prosecuting attorney's office did in this case. The prosecutor's office remains a neutral party and doesn't advocate for the merits of the petition or the charges that the petitioners filed with elections.
Okay, and Ms. Cook, given your statements, as far as the petitioner's efforts, or one could call it a motion to dismiss the recall petition, is the King County Prosecuting Attorney's Office just not taking a position on that? Is that correct?
That is correct.
Okay, very good. Thank you. Mr. Glitzen, good afternoon, sir.
Good afternoon.
Mr. Glitzen, long time no see. It's been a
Yes.
few years. Been a few years.
Yeah.
Okay, so Mr. Glitzen, I did my best to kind of encapsulate everything as far as kind of the procedural history, but then also what got us specifically here this afternoon. Is there anything you want to say just to kind of supplement the record, if you will, or do you feel like I've covered everything?
I feel like you have covered everything. Obviously, I do have a position that the mayor will be taking, but you're not asking for that from me right now, so I'll hold off on that.
Okay, so good lead in, Mr. Glitzen. So as far as just kind of the procedural history and what led us here, it sounds like you have nothing to add. Can you say for the record what is Mayor Wilson's position vis-a-vis, I'm just going to call this a motion to dismiss? Go ahead.
Yes, thank you. I guess procedurally, we have looked and haven't exactly found any very clear guidance, but it seems clear to us that it would be the King County Prosecutor's Office's role in its discretion to seek to withdraw the action that it initiated in King County Superior Court in compliance with the statutes, sort of unwinding. The recall petitioners filed the petition. It was transmitted to the King County Prosecutor's Office, which initiated this action. Now that the recall petitioners have said they don't want to proceed, and they have already failed to comply with your various different directives, it would be appropriate for the King County Prosecutor's Office to withdraw the petition, and Mayor Wilson does not oppose that happening.
Okay, so Mr. Glitzen, is that your plan A? And is that do you only have plan A? Is there a plan B as well? Because I'm gonna also hear from Ms. Cook as far as her position and what role the King County Prosecutor's Office should be taking as far as either dismissing the petition, withdrawing the petition, and so forth. So, go ahead.
I do have a plan B.
Okay.
So again,
I kind of figured. So
yeah.
Plan B is.
Plan B is if for some reason the King County Prosecutor's Office does not believe that it can move to withdraw the action that it filed, then I think it is appropriate for this court to treat the petitioner's request as a motion to dismiss the petition, and it's still, again, clearly appropriate to grant that request. There is no world in which a recall petition should move forward in King County Superior Court when the recall petitioner seeks to withdraw it, unless Mayor Wilson was asking you to reach a decision on the merits of the petition, which Mayor Wilson is not doing at this point.
Got it. Okay. Ms. Cook, what's King County Prosecutor's Office position as far as Mr. Glitzen's Plan A? So his first legal position is that the prosecutor's office actually should withdraw the petition. So what say you on that?
Well, Your Honor, first I will say that this is an unusual circumstance. And so
Oh my gosh, Ms. Cook.
And nobody does.
I'm glad you concur, because this whole process has been befuddling to the court, and I'm sure it's been equally befuddling to counsel on all sides. But sorry to interrupt. Ms. Cook, go ahead.
Yeah, no, of course. With regards to Plan A, I don't think there is clear guidance. There's certainly not any guidance under 29A56 regarding a request such as this for the recall petition to be dismissed. I don't think there is guidance that suggests the prosecutor's office, due to a request or what I would call a motion before the court, has the authority to withdraw or dismiss the petition. I think it is within the court's jurisdiction at this point. I think that would violate the prosecutor's role as being a procedural conduit for the court from elections who receive the petition and would give the appearance of advocating for a position. I don't disagree with Plan B, and that is that, I know you didn't ask me about Plan B, but I think that is the reasonable solution here, that the court treat the motion as a motion to dismiss, since the motion has been filed with Your Honor, and the court could rule appropriately based on that motion.
So thank you, Ms. Cook. I just want to correct one thing, and that is there's no motion that has really been filed in this case. So when we talk about motions being filed, what that requires is compliance with the King County local rules, getting them put into the court file, providing notice of a hearing, serving the opposing parties, and so on and so forth. None of that has been done in this case. So I think describing it as a motion having been filed is probably not correct. Now, what we do have for sure is the petitioners, Ms. Jacobson and Mr. Osterud, before the court, at minimum, making an oral request or oral motion that the petition be dismissed. So I just wanted to correct that. Okay, so thank you, Ms. Cook. Mr. Eagleton, any last words you'd like to make as far as argument on this issue?
I would, Your Honor, thank you. The decision by the recall petitioners to bring what we have characterized in our briefing, and I think is frankly beyond dispute, an entirely frivolous recall petition against Mayor Wilson, seeking to have her recalled for making what are clearly good faith, discretionary, and reasonable decisions as to how to fulfill her duties as mayor, has imposed substantial costs on King County Department of Elections, King County Prosecutor's Office, King County Superior Court, as well as the City of Seattle itself, the Mayor's Office, and Katie Wilson personally. The recall petitioners are constituents of Mayor Wilson. We appreciate that they have come to understand, I'm saying hopefully, that the content of their recall petition was frivolous, but I am troubled to hear in open court some suggestion that they might be thinking that they will simply wait for another day and file the same recall petition again. And under the statute, there is no statutory limit to how many times the same person can file a recall petition, but it is clearly at odds with the statutory scheme and numerous decisions of the Washington State Supreme Court that say that a recall petition should not be used as or seen as a substitute for the normal process whereby elected officials are elected at regularly scheduled elections. There's not an opportunity under Washington law to have sort of a vote of no confidence midway through someone's term. In the Supreme Court case, N. Ray Recall of Piper in 2015, the citation is 184 Washington 2nd, 780. The Supreme Court imposed or upheld the imposition of sanctions against a recall petitioner who brought a frivolous recall petition. And I feel like I would be doing the petitioners a disservice if I did not take this opportunity on the record in open court to put them on notice that while the mayor has no intent to seek sanctions against these recall petitioners for this recall petition, which they have now seen fit to seek to withdraw, should there be a repetition by these same individuals of another frivolous recall petition purportedly seeking to recall Mayor Wilson because they have come to believe that she's doing her job in a way that they are not happy with, that the mayor might need to direct this law firm to seek sanctions against them. We do not need to further burden the court by seeking a ruling on the merits of the current recall petition, even though under the law, such a decision would be res judicata against any future similar recall petition. That would be an option. We considered asking you to reject the request to withdraw the recall petition, to ask you to rule on the merits of the petition, and then we all would have repose and know that there would be no repetition of this. The mayor would prefer to optimistically assume that your ruling today dismissing the petition will be the end of it. But as I say, need to put everyone on notice that if it proves not to be the end of this matter, there will have to be an effort to require the recall petitioners to take responsibility for their abuse of the law and the process and this court's availability. Thank you.
Okay, thank you, Mr. Eagleton. So I'm going to go ahead and rule. So first of all, there is actual legal precedent for a withdrawal or dismissal of a recall petition. So Mr. Eagleton talked about a Supreme Court case in Ray recall Piper. It's 184 Washington 2nd 780. I believe that's a 2015 case. And then we also, hang on just 1 second, stand by. There's also the case of In Re the matter of Kinney, that's 31 Washab 2D 782. That's a 2024 case. So both in the Kinney case and the Piper case, petitioners actually voluntarily withdrew their recall petitions at the sufficiency hearing. So we're actually not at the sufficiency hearing today. We're at a status conference, but frankly, for all intents and purposes, there really is no difference. So there is actual legal precedent for withdrawing the recall petition. Petitioners, Ms. Jacobson and Mr. Osrud, actually have a right to withdraw their petition. So I am going to allow the withdrawal of the recall petition. So I just kind of want to be clear on what I'm doing today, but frankly, what I'm not doing today. So, one, I am going to sign an order dismissing the recall petition I'm gonna file that this afternoon, and so it'll be in the court file by close of business today. And what that order is going to do is it's going to dismiss the recall petition without prejudice. It also is going to cancel the sufficiency hearing we have scheduled for next Monday. Now, what the court is not doing, and Mr. E. Glitzen kind of teed up a couple of issues, but he's not asking me to rule on them today, would be two issues. One, the actual sufficiency of the recall charges that were brought forth. Mr. E. Glitzen is not asking me to rule on that. Petitioners are not asking me to rule on that. And as such, I'm not ruling on that today. The second thing Mr. E. Glitzen talked about, and the case of in re recall of Piper that the court mentioned a minute ago, and it's the cite's going to be to these cases will be in the court's order. What Mr. E. Glitzen made reference to is in that in re recall of Piper case, the court ultimately found that the petition, even though it was withdrawn, was actually frivolous and imposed sanctions and attorney's fees on the petitioners. Mr. E. Glitzen is not asking me to rule on that today, and frankly, there's not enough information before the court, even if the court were inclined to make such a ruling today, which I'm not. There's just not enough information before me. So as far as the issue of attorney's fees, I don't know if that's going to come up later. We shall see. I don't have a crystal ball, so I'm not sure, but I'm not ruling on that. I'm not ruling on sufficiency. So with that said, I am going to issue a written order, and it's going to dismiss this recall petition and cancel the hearing for next Monday. Ms. Jacobson, any brief questions for me?
No, I think you've covered it very well.
Okay, thank you. Ms. Cook, questions?
No questions, Your Honor. Thank you.
Okay, thank you. Mr. E. Glitzen, questions?
No, thank you, Your Honor. I think you've resolved this matter fully and completely.
Okay, thank you. That concludes the hearing. We're at recess.
All rise. All rise.
All right, well, you have been watching our live stream coverage of a hearing on the recall efforts against Seattle Mayor Katie Wilson. We have now learned the petitioners want that recall dismissed, and the judge has granted it. The petitioners who originally filed that recall charge, Melinda Jacobson and Dale Osterud, were there to explain why they missed a key briefing deadline yesterday. They say they wanted more time to investigate their claims, and again have made that request to dismiss their recall efforts for now. The judge saying in his words that this is highly irregular, but has granted the withdrawal of that petition. The recall charge was made earlier this month following the events of the deadly Seattle Center shooting and concerns over public safety. King 5's Bridget Chavez is in the courtroom right now covering all of this, and she'll bring us the latest starting today at 4 o'clock and, of course, streaming on our King 5 apps. Thanks so much for joining us for this breaking news stream. I'm Christine Pei. Until next time.